and he was presented with this affidavit from Judge Grisham. The proof will be that Judge Alred then prepared an order. And in that particular order, he convened and ordered a special grand jury to appear in the Harlan Circuit Court, and specifically designated in that order that it was designed to investigate illegal drug trafficking by the Harlan County Judge Executive from his office. The proof will be that Judge Alred then took that order and filed it with the Harlan Circuit Court clerk. That particular order then became the subject of media attention and was reported, showing Judge Executive Grisham to be the target of a special grand jury investigation just a few weeks before the May election, in which Judge Grisham was running against Denny Pace, Judge Alred's cousin. And this order is significant in that the special grand jury was not going to be able to convene until May 25th, after the primary election. The proof will be from these facts and from the testimony that we're going to present before you is that Judge Alred entered this special grand jury order to retaliate against Judge Executive Grisham for signing that affidavit in the Potter v. Howard case, and to influence the election for Judge Executive in Harlan County in order to enhance the chances that his cousin would win that particular election. After that order was entered, media attention was then focused on this particular investigation. The Commonwealth Attorney will testify that he felt that order was wrong, that he felt it had to be released by Judge Alred, and he didn't feel, with the evidence that he had seen, that it was right for Judge Executive Grisham to be tainted with that type of perception. As a result, proof will be that the Commonwealth Attorney, Henry Johnson, then presented the evidence to the regular grand jury in Harlan County on May the 3rd of 2010, before the primary election. Proof will be that he presented the testimony of Ms. Hensley, Police Officer Hensley, the investigators from the Sheriff's Office, and polygraph evidence from Judge Grisham indicating that he passed and had not been involved in any type of illegal drug sales. The jury returned a no true bill based on what was presented before the grand jury. When Judge Alred learned that day that the Commonwealth Attorney had presented the case to the regular grand jury, the proof will be that he then summoned the Commonwealth Attorney to his office, that he was quite angry, that he confronted him about what he had done, and as a result, and in retaliation we submit for what the Commonwealth Attorney had done, Judge Alred then revoked the secure courthouse access for Commonwealth Attorney Johnson and Sheriff Marvin Lipford. Counts 14 and 15 involve John Clem, a cousin of Judge Alred. We will present evidence that John Clem was and is a cousin of Judge Alred, who worked at the Harlan County Jail until August of 2008. Mr. Clem now works for, to the best of my knowledge, the Harlan County Drug Court and is an employee of the Harlan County Fiscal Court. We will present testimony that Judge Alred contacted Kurt Stallard, the Harlan County jailer, and asked him not to contest Mr. Clem's application for unemployment, even though Mr. Clem had voluntarily resigned his employment at the jail. And as a result of Judge Alred's request, Mr. Clem, the county did not contest it, and Mr. Clem received unemployment benefits. We will also present testimony through Mr. Stallard that Judge Alred used his influence to have his cousin, Mr. Clem, hired by the Harlan County Drug Court. Counts 9 and 10 of the charges involve James Howard, who I've outlined to you before, involved in some of the other counts. We will present testimony that Judge Alred personally contacted the Kentucky State Police and the Harlan County Sheriff and urged them to investigate Mr. Howard for operating poker gaming machines at his gas stations, and asked them to investigate, seize the machines, stop their operation in these gas stations. Mr. Howard, along with another individual, were indicted as a result of an investigation. Judge Alred, despite the fact that he'd had ex parte conversations with the Kentucky State Police and the Sheriff's Office, then presided over this particular case involving Mr. Howard and approved a plea agreement that was conducted at a hearing without the presence of Mr. Howard's counsel. Faced with this particular information, because this happened in 2008, Judge Alred, it was another grounds as to why Judge Alred should have recused when Potter versus Howard came on for hearing on April 22nd of 2010. Count 5 involves Robin Teschon. Ms. Teschon was a substitute teacher in Harlan County, working at James A. Kaywood Elementary School, where Judge Alred's wife works, his sister works, his children go to school. At some point in 2009, Ms. Teschon was charged with insurance fraud. When Judge Alred learned of this particular charge, the proof will be that he contacted Mr. James Clem, the school principal, and urged him to terminate Ms. Teschon, not to use her as a substitute teacher. The proof will be that Mr. Clem checked with the superintendent, reported back to Judge Alred. She hasn't been convicted. There's nothing, according to district policy, that prohibits her from serving as a substitute teacher. After hearing this information from Mr. Clem, the school principal, Judge Alred then ordered, as a condition of her bond, that Ms. Teschon no longer perform substitute teaching. That was a term and condition of her bond. Counts 12 and 13 involve Judge Alred's efforts in fundraising in his capacity as a judge. There will be proof that Judge Alred filed a complaint with the Public Service Commission in April of 2008. Teschon, in this particular no longer performed substitute against teaching. Kentucky Utilities, that was a term and condition of her bond. He alleged that he himself and some of his companies were illegally assessed and charged a fuel adjustment charge. After Judge Alred filed this complaint with Kentucky Utilities on behalf of himself and his companies, he then had a conversation with Kentucky Utilities Counsel in which he agreed to dismiss that complaint in exchange for a $12,500 contribution to James A. Kaywood Elementary School to purchase playground equipment. You will also hear testimony, I don't think it will be undisputed, that Judge Alred engaged in other fundraising activities, soliciting funds from companies and individuals in Harlan County for playground equipment at James A. Kaywood Elementary School. Another count that will be presented before you is Wallace Smith. There will be testimony that Judge Alred engaged in ex parte conversations with Sheriff Lipford regarding Mr. Smith, advocating that Mr. Smith be investigated and indicted for drug trafficking. And this fact will be undisputed. After Mr. Alred was indicted, after Mr. Wallace Smith was indicted, Judge Alred then presided over his case. The last count from which we will present evidence to the Commission involves count 17. Kotha Hudson is a public defender who was working in Harlan County. The proof will be that Ms. Hudson missed court appearances in Harlan County. The proof will be that Judge Alred, without notice and without a hearing for Ms. Hudson, entered an order removing her from all cases in Harlan County and preventing her from representing criminal clients in Harlan County, without notice and without a hearing for her. I anticipate that you will hear a great deal of testimony and evidence from Judge Alred and his witnesses that these charges are concocted, that it's a result of a conspiracy by the Commonwealth Attorney and the Sheriff, that it's done for political gain. But I submit that when you hear all of the evidence, Judge Alred, at least for a great number of these particular charges, will not be able to dispute the facts that I've outlined for you. At the end of the day, the evidence is going to show this Commission that Judge Alred failed to uphold the integrity of the judiciary. He's failed to avoid impropriety by allowing his family and political relationships to impair his objectivity. That he's disregarded the law, that he's engaged in ex parte conversations and failed to recuse in cases where he needed to and the law said he had to. And that Judge Alred used the prestige of his office as judge in Harlan County to promote his own political and personal agenda. Thank you.
Judge Alred, do you wish to make an opening at this time?
I do, Mr. Chairman. Judge Alred.
Ladies and gentlemen of the Commission, Mr. Chairman, that's a really good fiction. It's a really good story, Mr. Mando told. But the simple fact of the matter is, this grand political scheme that I'm supposed to have to further my career as a judge just isn't there. In regard to the allegations made in regard to my cousins for that purpose, you need to understand something before we start. Just the other day, I went with my dad down to a family cemetery in the flatter end of Harlan County, and in that cemetery is my 7th great-grandfather, Ephraim Osborne. He was a captain in the Revolutionary Army, and he got a land grant to come to where we live now, way before it was even Kentucky, when it was still Virginia. And on the other side of my family, who are the Baileys, that's how we ended up in Harlan County. And anybody that's from eastern Kentucky or in a small town in the Commonwealth of Kentucky, when you use the word cousin, you use it very loosely. If you get into my third cousins, which Mr. John Clem is, that was referenced by Mr. Mando, I never even knew John Clem until he was working at the jail and I was a practicing attorney. When you use the word third cousin, they won't use that word. They say cousin. For judicial ethics, we don't even consider that for judicial ethics. 3 degrees of relation from us. Mr. Clem was 6 degrees of relation from me. So for judicial ethics, it really doesn't make a difference, the nomenclature of cousin. That's done, for my opinion, purely show. And that's what a lot of this case was about. Do you ever wonder why there were so many allegations? Do you ever wonder why, and this is what the evidence will show, why they split the fundraising allegations into 2? Why they split the pretrial drug testing into 2? Do you ever wonder why that happened? In regard to Mr. Clem, John Clem, Mr. Weaver that was in here, and Mr. Robbie, made a lot of trips to Harlan County. The evidence will show you that Mr. Weaver actually came to Harlan County well over 30 times to interview witnesses, and oftentimes interviewed witnesses 8, 10, 12, 15 times. You heard a lot of argument here in regard to Mr. Joseph Grisham, about how this grand jury was convened for a political motive. Well, you know what, folks? Judge Executive Grisham will testify on my behalf in this hearing. That's been the dirty little secret that's gone on all through this. He will testify on my behalf. He signed an affidavit asking that the allegations involving him be dismissed against me. He will testify that I did the right thing. He will testify that Marvin J. Litford, Harlan County Sheriff, and Henry S. Johnson were opportunists. You will hear numerous witnesses testify that Marvin Litford, the Sheriff of Harlan County, who were the political opponents or political candidates in the election when this was going on, talked to them and told them that he had Judge Executive Grisham and he was going to indict him, not to worry about him in the election. He would tell them that you're going to hear a magistrate candidate testify that he was told by the sheriff, I've got Joe Grisham, I'm going after Paul Caldwell next, which was his political opponent. That's what this is about. You're not going to hear anybody testify that Judge Alred was running around telling everybody that there was an investigation on Joe Grisham. You're going to hear numerous people talk about the sheriff talking about it well before the special grand jury was ever convened. You're going to hear testimony and a tape from a fellow named Roger Sizemore, who is a close personal friend of Henry S. Johnson, the Commonwealth Attorney, a gentleman who was just recently arrested for DUI drugs on July the 28th, with the Commonwealth Attorney standing there visiting with him, taken to jail. You're going to hear testimony, and you note they mentioned that Kurt Stallard was going to testify that Judge Alred called him and used his heavy hand and his prestige to keep him from fighting him in an unemployment case, and that they were going to create a job for him down there at the courthouse. Well, you know what Mr. Mando left out? John Clem was running against Kurt Stallard for jailer. He left out that Kurt Stallard actually gave 2 statements to the investigator for the Judicial Conduct Commission, and you'll see that. One of them, first part of September, says that I'm the best judge, I'm better than sliced bread, to put it in a paraphrase. I'm a fine judge, I'm a fine person, that Henry Johnson is lazy, he's a scoundrel, over and over in that statement. Well, right before the election, there's another statement taken, a mystery statement, October the 20th. There's no explanation of why Gene Weaver, the investigator for the JCC, ended up back down there taking a statement from Kurt Stallard. This is a very different statement. Immediately goes into all this information involving John Clem. Immediately. You'll not hear an explanation of why that happened from Mr. Stallard, but the real reason, and the testimony will elicit, that Henry S. Johnson went to him, lied to him, and convinced him that I was helping John Clem in the election. And in Harlan County, I don't know how other counties are, when it's election time, I have never seen more cutthroat activity in my life. I never was involved in any part of any election, whether the judge executives, and you'll hear testimony from me to that effect. You'll hear testimony that the sheriff was extremely interested in it. You'll hear a fellow named Sean Miller testify that he got a call in January, late December, early January, to come down to the sheriff's office. And the sheriff was down there and said, hey, Sean, don't worry about it. He said, Joe Grisham, I'm going to indict him. Things are looking good for you for judge executive. Does that sound like what Mr. Mando said, that the sheriff was forced into this special grand jury? You will hear a recorded statement. May I have permission to move around a little bit? Is that okay, Mr. Chairman? You will hear a recorded statement of Henry S. Johnson, who called a press conference on the day that the special grand jury was in. Was the special grand jury returned, the regular grand jury returned to no truth. He called a press conference. And in his press conference, he says, I agreed with the special grand jury. I, meaning him, agreed to it. It is hard to comprehend if someone in their own words says they agree with the special grand jury, how Mr. Mando's story can make sense. He says they will prove that I used a heavy hand to force them into a special grand jury. The Commonwealth Attorney, you'll hear his own testimony at his own press conference he called, said he agreed with the special grand jury. As Mr. Mando said, the special grand jury had to be skipped, according to the Commonwealth Attorney, who will testify. He'll testify that it had to be skipped because the special grand jury was made public. Well, you know what you're going to hear testify here today? You're going to hear Noah Sizemore of the Harlan Daily Enterprise testify that Henry S. Johnson called her on the Monday before the story broke in the media, had her come to his office, gave her a copy of the special grand jury order, told her not to say anything about it, and then they had the judge executive come to the Harlan Daily Enterprise, show him a copy of the special grand jury order, and lie to him and tell him that she had got it from Judge Russell Alred. Now, if you note, initially Judge Grisham had given testify, pretty bad testify that it had to be skipped. But you must understand, and the evidence will show, that is why. Because he was lied to by the newspaper reporter. The Commonwealth Attorney released the special grand jury order. In addition, the Commonwealth Attorney not only released a special grand jury order to Noah Sizemore, your all's own investigation through Gene Weaver showed that the Commonwealth Attorney